Good morning. I hereby call to order this third meeting of the Pennsylvania Public Utility Commission for the year 2024. We welcome everyone joining us in the room today and those of us joining on the live stream. Please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At today's meeting, which is open to the public, the Commission will act on various matters. There is no opportunity for the public to address the Commission at this public meeting. The public meeting motions, statements, and video will be available on the Commission's website later today. The first matter on this morning's agenda is the approval of the minutes of the meeting of January 18th, 2024. I would like to recognize Vice Chair Barrow as the editor of the minutes. Vice Chair Barrow.
Thank you, Chairman. I have reviewed the minutes and, hold on one sec. Sorry about that. I've reviewed the minutes and they are fine. Thank you.
Thank you, Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Yanora. Is there any discussion? Hearing none, all those in favor to approve the minutes, please say aye.
Aye.
Aye. Those opposed, no. Minutes are approved by a vote of 5-0. Madam Secretary, we are ready for your presentation.
Good morning, Mr. Chairman. Good morning, Commissioners. Your offices have prepared the following agenda for your consideration. Therefore, let's begin on page 1 with the recommendation of Director Vermont and the Bureau of Administration that the Commission approve the Evaluation Committee's recommendation for selection for Human Resources Legal Counsel Services.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Vice Chair Barrow. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it. Matter passes by a vote of 5-0. Madam Secretary.
Turning to page 2, it is recommended by Director Montague and the Bureau of Audits that the Commission adopt the auditor's report on steam and chilled water cost rates for the Energy Center of Pittsburgh LLC and release the audit report to the public.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfas, seconded by Vice Chair Barrow. Any discussion?
Chairman, I do have a motion.
Vice Chair Barrow.
Thank you. Madam Secretary, please enter my motion into the record as though I read it in its entirety. Before us for disposition is the Bureau of Audit's report on Energy Center Pittsburgh's steam cost rate and chilled water cost rate for the 12-month periods ended June 30th, 2021 and June 30th, 2020, and the 16-month period ended June 30th, 2019. Energy Center operates 2 separate steam and chill water generating plants in Pittsburgh. The North Shore plant provides service to 24 customers in 30 buildings. The second plant, the Uptown Corridor plant, was constructed in 2017 and began providing steam heat in 2018 and chill water in 2018. All that to say, they've not been with us all that long. So on August 31st, 2020, the Commission released an audit report of Energy Center for the 12-month periods ended in June of 2018 and June of 2017. In the 2020 report, audits highlighted Energy Center's noncompliance regarding a prior recommendation that the company had billed incorrect chilled water rates during July 2014 and 2015, which resulted in a net overbilling of $7,000 and change. That's the 2016 report. Audit specifically recommended that the company make an adjustment to each customer's bill based upon original volumes to correct for the 2014 and 2015 incorrect rates, and that they develop procedures for verifying rates prior to billing customers. Nonetheless, audits noted in the 2020 report that as of the end of the audits, Energy Center had not made the recommended adjustments and had not developed procedures, remedial procedures. So they once again directed the company to make those changes. Additionally, in the 2020 report, based on a finding of reported inaccurate revenue and expenses, audits directed the company to develop appropriate and effective internal controls and procedures to ensure accuracy of billed and reported revenues and expenses. Surprisingly, despite accepting the findings and recommendations, the audit report notes that Energy Center has not complied with the recommendation in the 2020 report, and there have been no changes made. So definitely there's a problem going on here, and as a PUC regulated entity, I do, and I think we all do, expect Energy Center to comply with commission regulations and the code, especially when it comes to providing accurate information dealing with rates and billing. So therefore, I believe this matter should be referred to the Commission's Bureau of Investigation and Enforcement for any further action deemed warranted by that bureau. And I move that the Bureau of Audit's report on Energy Center Pittsburgh LLC's steam cost rate and chill water cost rate be made public, that the matter be referred to the Commission's Bureau of Investigation and Enforcement for any further action as deemed warranted based on the Bureau of Investigation and Enforcement's review, a secretarial letter be issued notifying Energy Center Pittsburgh of the Commission's action, and finally, that the Office of Special Assistants draft an opinion and order consistent with this motion.
Thank you. We've heard the motion by Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion? Hearing none. All those in favor, please say aye.
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 Those opposed, no. Motion passes by a vote of 5-0. On the matter as amended by the motion, is there any objection to taking the previous roll call? Seeing none, matter passes as amended by a motion by a vote of 5-0. Madam Secretary.
Turning to page 3, it is recommended by Executive Director Barrier and the Office of Executive Director that the Commission adopt the proposed order appointing Alicia Bozick to fill a vacancy on the Damage Prevention Committee.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 4, in matters presented by Director Hafner and the Office of Special Assistants, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint and subsequently filed petitions in Michael W. Chatton et al. Versus the Pennsylvania Electric Company, Metropolitan Edison Company, and the West Penn Power Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Unora, seconded by Commissioner Zerfus. Any discussion?
Mr. Chairman, I do have a statement.
Vice Chair Barrow.
Thank you. Please enter my statement into the record as though I read it in its entirety. These are smart meter safety complaints, and I agree with the result in the cases, but in some of the cases, I do want to point out that I believe that the standards applied were incorrect, the legal standards. For example, in Toth versus Met Ed, exceptions filed 5 days late were treated as a petition for rescission, and the DUIC standard was applied. Instead of treating the late filed exceptions as a petition for rescission, I would have addressed them as exceptions. Even so, the application of DUIC was not correct. DUIC does not require new or novel arguments to be made. It merely advises that if new and novel arguments are not made, then the reconsideration would likely be denied. The commission must instead address the persuasiveness of the reasons for reconsideration. Also, I believe that our disposition misstates the nature of dismissal for failure to prosecute. And I cite to Jacobs versus Halloran, Pennsylvania Supreme Court case, which establishes the proposition that actual prejudice must be shown to dismiss a case for failure to prosecute beyond the mere time of delay. In Jacobs, the court held that was true even after a 6-year delay. I am not urging for a 6-year delay. I'm just saying. The dismissals here with prejudice for failure to prosecute have not demonstrated the actual prejudice required by Jacobs. Thank you.
Thank you, Vice Chair Barrow. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no.
No.
Aye. Oh, I'm sorry. The matter passes by a vote of 4-1, noting the dissent of Vice Chair Barrow. Madam Secretary.
Continuing on page 4, it is recommended that the commission adopt in an omnibus motion the remaining item on page 4, the formal complaint of Kim Martin versus the Metropolitan Edison Company, and continuing and ending the omnibus at the top of page 5 with the formal complaint of Diana Sabatine versus the West Penn Power Company.
Is there a motion to consider the staff recommendations?
So moved.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it. Matters passed by a vote of 5-0. Madam Secretary.
Continuing on page 5, it is recommended that the commission adopt the proposed opinion and order in the formal complaint of Judith Hendon versus the Metropolitan Edison Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, seconded by Commissioner Coleman. Any discussion? I do have a statement in this matter. Before joining my staff as legal counsel, Joel Cheskis was employed in the Commission's Office of Administrative Law Judge and worked on this case. Please note he has not advised me in this matter. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 6, it is recommended that the commission adopt in an omnibus motion both items on page 6, beginning with the formal complaint of Lydia and Alan Rieger versus the Metropolitan Edison Company, and continuing the omnibus to include both items on page 7, pausing at the top of page 8 to note that the formal complaint of Michael Markovsky versus the Metropolitan Edison Company has been postponed to the public meeting of March 14, 2024, and then continuing the omnibus to include the remaining item on page 8, the formal complaint of Thomas and Deirdre McLean versus Metropolitan Edison Company, and to continue, include, and end the omnibus at the top of page 9 with the joint petition of the Metropolitan Edison Company, the Pennsylvania Electric Company, the Pennsylvania Power Company, and the West Penn Power Company, collectively First Energy.
Is there a motion to consider the staff recommendations?
So moved.
Motion made by Vice Chair Barrow, seconded by Commissioner Yanora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Continuing on page 9, it is recommended that the commission adopt the proposed opinion and order in the application filed by the Pennsylvania American Water Company to acquire the wastewater assets of the borough of Brentwood in Allegheny County.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, seconded by Vice Chair Barrow. Any discussion?
Chairman, I do have a motion.
Vice Chair Barrow.
Thank you. Please enter the motion into the record as though I read it in its entirety. I will not. This matter concerns the application filed by Pennsylvania American Water Company on March 31st, 2023, pursuant to Sections 507, 1102, and 1329 of the Public Utility Code. In the application, Pennsylvania American requested approval to acquire substantially all of the assets, properties, and rights related to the wastewater collection system owned by the Borough of Brentwood, and the right for the company to provide wastewater service in the areas served by that borough. The application also requested, pursuant to Section 1329C2 of the code, the Commission's approval to utilize fair market value for rate making rate base of the system, for the rate-making rate base of the system. And finally, under Section 507 of the code, they requested approval of an asset purchase agreement and the cooperation agreement between Brentwood and PA American, as well as other municipal agreements to be assumed by the company as a result of the transaction. The ALJ's recommended decision denied the application because PA American did not meet its burden of establishing that there is an affirmative public benefit resulting from the acquisition of Brentwood's system. And what we have before us now are exceptions filed by PA American and the borough. I will focus in on the main exception, and that is that PA American argues that the recommended decision erred in its conclusion that the net detriments of the transaction outweigh the net benefits for the public at large. The borough's existing customers and PA American's existing water and wastewater customers. In addition, the company contends that the recommended decision did not weigh the benefits against the detriments of the transaction as a whole correctly. I agree with the ALJ's recommendation to deny the application because Pennsylvania American failed to present sufficient evidence to sustain a finding that substantial affirmative public benefits will result from the acquisition of the Brentwood system, and that we should issue a certificate of public convenience. I also agree with the ALJ's conclusion that because there is not sufficient proof of a public benefit, the request to approve the agreements become moot because the asset purchase agreement is relevant only if the acquisition is approved. Also, the ALJ determined that other issues, corollary issues, became moot and so decided not to address them. I agree with that. Specifically based upon the analysis under sections 1102 and 1103 of the Public Utility Code, that the alleged benefits to be realized from the proposed acquisition do not outweigh the resulting harms from it, it is not necessary to consider the additional approval request under sections 507 and 1329 of the code. For these reasons, the exceptions of Pennsylvania American and the exceptions of Brentwood are denied, and I move that exception. Even though I truncated my remarks, I'm gonna make some references in the moving paragraphs that you may not have heard, but it'll all come together. Therefore, I move that exception number 1 of Pennsylvania American Water Company filed on January 24th at docket number A 2021-302-4058 is denied consistent with this motion. That exceptions number 2 and 3 of Pennsylvania American Water Company are considered moot, consistent with this motion, that the exceptions of the Borough of Brentwood are denied, consistent with this motion, that the recommended decision of Administrative Law Judge Katrina Dunderdale, issued on January 17, 2024, is adopted, consistent with this motion, that the application filed by PA American pursuant to Sections 507, 1102, 1103, and 1329 of the Code for approval of its acquisition of the wastewater collection system assets of the Borough of Brentwood are denied, consistent with this motion, is denied, consistent with this motion, that the Office of Special Assistants prepare an opinion in order consistent with this motion. Thank you.
Thank you, Vice Chair Barrow. We've heard the motion by Vice Chair Barrow. Is there a second?
Second.
Seconded by Commissioner Zerfas. Any discussion on the motion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Those opposed, no. Motion passes by a vote of 5-0. On the matter as amended by a motion, any further discussion? I do have a statement. I ask that my statement be entered into the record as though I read it in its entirety. Before the Commission is the application filed by Pennsylvania American Water Company, or PAWC, and the Borough of Brentwood. The application was filed pursuant to Sections 1102 and 1329 of the Code, seeking approval for PAWC's acquisition of Brentwood's wastewater conveyance system. The presiding administrative law judge recommended denial of the application. It is incumbent on the Commission to balance the overall benefits of any 1329 application with the overall detriments to determine if the transaction offers substantial affirmative public benefits. This application presents a unique set of circumstances in comparison to other 1329 proceedings I have supported. This is the case since Brentwood contracts its wastewater treatment to a third-party municipal entity, Alcosan. As such, Brentwood is simply a wastewater conveyance enterprise, comprised of mainly pipes and manholes, and therefore the only improvement PAWC has to offer in these circumstances is the replacement of said pipes and manholes. This then begs the question as to the condition of the Brentwood infrastructure. The record here shows that Brentwood currently has no direct issues of environmental noncompliance. Rather, Brentwood is an indirect party to a modified consent decree between Alcosan, the Environmental Protection Agency, the Pennsylvania Department of Environmental Protection, and the Allegheny County Health Department. The record also indicates that Brentwood has been meeting the milestones required by the decree. While I have no doubt that PAWC would meet these milestones as well, it cannot be ignored that this would simply be upholding the status quo and not an incremental improvement. Moving on, I note the relative financial condition of Brentwood's conveyance system based on the difference between its original cost and its depreciated cost. Both valuation experts calculated original cost figures of approximately $9.94 million. The record indicates accrued depreciation reserves of $3 and $2.6 million respectively. Such appraisals result in an average depreciated original cost of approximately $7 million compared to an average original cost of $9.94 million. I believe these financial metrics are indicative of a system that has been productively managed since it still includes a relatively significant amount of undepreciated asset value. Finally, I highlight the proposed transaction cost in the application of $19.36 million. The 1329 statute clearly permits acquisitions to be made above the depreciated original cost, but the Commission is empowered to review the transaction price in its overall analysis of any application. I submit that the transaction price premium above depreciated original cost, which here comes to approximately 173%, coupled with resulting rate impacts manifested by the transaction price, support upholding the recommended decision here given the minimum public benefits that this transaction has to offer. In summary, balancing the numerous variables on the record with a particular focus on the issues highlighted above support denial of the application. While no single concern in the and the application individually disqualifies the transaction from approval, the collective aggregate of each of these circumstances warrants a denial. More specifically, the 1329 price premium is not warranted when balanced with the operational circumstances and asset condition of the Borough of Brentwood's wastewater conveyance system. Therefore, I must concur with the recommended decision and vote to deny the application. Finally, given all these circumstances, I encourage PAWC and Brentwood to consider filing a 1102 application should they wish to further pursue this transaction. Any further discussion? Hearing none. Is there any objection to taking the previous roll call? Hearing none, the matter passes as amended by the motion by a vote of 5-0. Madam Secretary.
Turning to page 10, it is recommended that the Commission adopt the proposed opinion and order in the complaint filed by the PUC's Bureau of Investigation and Enforcement versus the Buffalo and Pittsburgh Railroad.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Yonora. Any discussion? I do have a motion in this matter. I ask the Vice Chair to chair the meeting.
Thank you. I recognize Chairman DeFrank for purposes of his motion.
Thank you, Vice Chair Barrow. I ask that my motion be entered into the record as if I read it in its entirety. Before the commissions are the exceptions filed by Buffalo and Pittsburgh Railroad to the recommended decision by Deputy Chief Administrative Law Judge Mark Hoyer. The decision recommended approving the joint petition for approval of settlement filed by Buffalo and Pittsburgh Railroad and the Commission's Bureau of Investigation and Enforcement. The settlement resolves allegations that the railroad altered an above-grade crossing at Harrisburg Hollow Road in Knox Township, Jefferson County, by removing the steel bridge superstructure without first obtaining Commission approval. Under the terms of the settlement, the railroad agreed to pay a civil penalty of $17,500 and file applications to abolish 13 at-grade crossings in Armstrong and Jefferson counties within 90 days of an order approving the settlement. The railroad filed exceptions to the recommended decision. The exceptions raise issues that the language used by DCALJ Hoyer in his analysis of the factors the Commission uses to evaluate proceedings involving violations of the Public Utility Code and Commission's regulations. The Commission's regulations provide that when timely exceptions are filed to a settlement petition, the exceptions will be considered in a ruling made on the settlement. In reviewing the merits of the settlement, I disagree that the terms of the settlement meet the benchmark standards of being in the public interest. Buffalo and Pittsburgh Railroad admits that the Harrisburg Hollow Road crossing was altered without Commission approval. The steel superstructure was removed on January 8, 2020. It carried rail traffic over the roadway and was located on a 40-mile portion of an abandoned railroad line that crosses Jefferson and Armstrong counties. Its removal was discovered by a representative from the Commission's Bureau of Technical Utility Services Rail Safety Section during an in-person field conference that was held on February 21, 2020, in relation to a separate proceeding. On September 21, 2022, the railroad filed an application with the Commission seeking approval for the January 2020 removal of the steel superstructure at Harrisburg Hollow Road crossing. This came 32 months after the action was taken. The agreed upon civil penalty of $17,500 represents approximately 3.5% of the original civil penalty requested by I&E in its complaint, which was $494,000. Moreover, the agreed upon civil penalty does not appear to be supported by the factors the Commission uses to evaluate proceedings involving violations of the Public Utility Code and Commission regulations. First, the conduct alleged by this proceeding is serious. The removal of a steel superstructure by the railroad without first applying for and obtaining Commission approval constitutes a knowing and serious violation of the Public Utility Code. The Commission's jurisdiction over rail highway crossings is clear. Buffalo and Pittsburgh Railroad, as a regulated utility, should be aware of and knowledgeable about the requirement to seek approval from the Commission for the alteration of public crossings. Next, when evaluating a civil penalty that is in the public interest, the Commission also considers the duration of the violation. The record reflects that 987 days elapsed from when the railroad removed the steel superstructure and finally filed an application seeking approval to remove the superstructure. The long duration of this violation supports a greater civil penalty. Finally, the agreed upon civil penalty is not consistent with past Commission decisions in similar situations. In 2001, 23 years ago, the Commission imposed a civil penalty of $35,000 on a railroad for removing, restoring, and elevating tracks and barricading the crossing to vehicular and pedestrian traffic without a Commission order authorizing this alteration. In that matter, the railroad argued that there is no threat to public safety arising from the unauthorized alteration. However, the railroad did not dispute that it was unlawful to alter the crossing without Commission approval. The Commission determined that the violation lasted for 350 days and imposed a per-day civil penalty of $100 for a total civil penalty of $35,000. The 2001 matter was a fully litigated proceeding. This matter presents similar facts, and therefore I find it difficult to accept a civil penalty that is 50% less than one obtained 23 years ago under very similar circumstances. I'm also not persuaded that the additional terms of the settlement offset a lower civil penalty amount. The agreed upon corrective measures in the settlement involve an agreement for Buffalo and Pittsburgh Railroad to file applications to abolish 13 additional crossings in Armstrong and Jefferson counties. I acknowledge that the settlement may expedite the filing of these applications. However, railroads are already required under the Public Utility Code to obtain Commission approval prior to abolishing any crossing. Agreeing to perform a measure that a utility is already obligated to complete does not provide a benefit weighing in favor of the settlement being in the public interest. Lastly, Buffalo and Pittsburgh Railroad argues in its exceptions that there is no evidence to support that its actions created potentially unsafe conditions. The Public Utility Code clearly requires Buffalo and Pittsburgh Railroad to first obtain Commission approval to alter its facilities that are located across any highway at grade or above or below grade. Longstanding case law holds that when the legislature declares certain conduct to be unlawful, it is the same as calling it harmful to the public. Commission review and approval of crossing alterations is necessary for public safety. The Commission may direct that certain safety measures be put in place after an alteration occurs, such as installation of fences or barriers to prevent persons from accessing or the remaining railroad structure, requiring inspections or issuing orders related to maintenance. Buffalo and Pittsburgh Railroad deprived the Commission of its duty and ability to protect the public safety by altering the crossing without approval. For these reasons, I believe the civil penalty should be increased to $35,000. A $35,000 civil penalty aligns with the previous civil penalty that the Commission imposed for the same violation and reflects the seriousness of the violation. I find that the violation of this proceeding lasted for 987 days, from the date that the railroad removed the steel superstructure to the date when it filed an application. A civil penalty of $35,000 represents a per-day penalty of $35.46, an amount that is well within the statutory limits set forth in the Public Utility Code and more reasonable than the $17.73 per day civil penalty that the agreed upon penalty of $17,500 represents. I acknowledge that the case from 2001 imposed a per-day penalty of $100 per day. A lesser per-day penalty is justified in this proceeding to be consistent with the Commission's policy to encourage settlements. I find that all other terms of the settlement should be approved without modification. Therefore, I move that 1, the exceptions filed by the Buffalo and Pittsburgh Railroad Incorporated, filed on October 24, 2023, to the recommended decision of Deputy Chief Administrative Law Judge Mark A. Hoyer at docket number C-2021-302-6819 are denied. 2, The recommended decision of the Deputy Chief Administrative Law Judge Mark A. Hoyer, issued on October 17, 2023, at docket number C2021-302-6819, is modified. 3, the joint petition for approval of settlement filed by the Bureau of Investigation and Enforcement and the Buffalo and Pittsburgh Railroad Incorporated on July 14, 2023, is modified consistent with this motion. 4, the Bureau of Investigation and Enforcement and the Buffalo and Pittsburgh Railroad Incorporated may file a letter within 20 days of entry of an opinion and order withdrawing from the settlement. 5, if notice of a withdrawal from the settlement is timely received, the matter shall be remanded to the Office of Administrative Law Judge. 6, if no notice of a withdrawal from the settlement is timely received, the Buffalo and Pittsburgh Railroad Incorporated shall pay a civil penalty pursuant to Section 3301 of the Public Utility Code of $35,000 within 30 days of the date of entry of the opinion and order. 7, the civil penalty shall not be tax deductible or pass through as an additional charge to the Buffalo and Pittsburgh Railroad Incorporated customers in Pennsylvania. And 8, the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you, Vice Chair Barrow.
Thank you, Chairman. Is there a second for the motion?
Second.
Seconded by Commissioner Unora. Any discussion on the motion? Hearing none. All those in favor of the motion, say aye.
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 Aye. Any objections? On final adoption, is there any objection to taking the previous roll call vote? Okay, hearing none, I do wish to offer a conflict statement. Prior to joining my staff, Kayla Ross was employed by BINE and was assigned to this case. She has not advised me on this matter. All right. Hearing none, the matter is adopted as amended by the motion of Chairman DuFrank by a vote of 5-0, and noting my conflict statement, I return the gavel.
Thank you, Vice Chair Barrow. Madam Secretary.
Continuing on page 10, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint of Rob Naborn and Cynthia Pronko versus the PECO Energy Company and Direct Energy Services, LLC.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfas, seconded by Vice Chair Barrow. Any discussion?
Chairman, I do have a motion.
Vice Chair Barrow.
Thank you. Please enter my motion in the record as though I read it in its entirety. Robert Naborn, he's a shopping customer of Direct Energy and a PECO distribution customer. July 22nd, 2022, Mr. Naborn contacted PECO and, using PECO's automated system, accidentally switched his gas and electric supplier to PECO when he only intended to switch his electric supplier to PECO. Although PECO's system confirmed that he wanted to switch, it did not specify what should be switched. He stayed on the call. He explained his mistake to a PECO customer service rep and asked for the change to be reversed. The customer service rep could not override the switch initiated by the automated system. The same day, Mr. Naborn contacted Direct Energy to inform them of the accidental switch and asked them not to accept it. The Direct Energy rep advised that they had not yet received any change in status, and Mr. Naborn requested that the Direct Energy rep note the forthcoming switch request would be an error. Despite his efforts, PECO sent a notice to Direct Energy of the switch request, which Direct Energy accepted. After some months of negotiation with Direct Energy and PECO, Mr. Naborn filed a formal complaint with us against both companies. And ultimately, in March of 2023, he was placed back on his original Direct Energy contract terms with an extended term. The ALJ's initial decision found that PECO violated the Public Utility Code and ordered a civil penalty and refund of the difference between the PECO rate and the Direct Energy rate. PECO did not file exceptions and hasn't had to pay a civil penalty. The refund aspect of, and has paid the civil penalty, sorry. The refund aspect of the initial decision has made the customer whole. The ALJ found that Direct Energy violated Section 1501 of the Public Utility Code, and Direct Energy filed 3 exceptions. First, Direct Energy argues that it cannot violate 1501 of the code because it is not a public utility. I agree with that. Direct Energy's second exception is generally that no civil penalty is justified because it did not provide inadequate service, did not provide misleading information, and did not willfully mislead the complainant. Direct Energy's third exception is that the Commission has no power to force it to enter into or revive a contract. This matter presents some unique facts. The Commission supplier regulations protect customers from switching performed by people not authorized to act on the account, what we know of as slamming. But here, Mr. Naborn had the authority to take the action on the account, although the prompts that he selected in the IVR were incorrect. But with Mr. Naborn immediately notifying Direct Energy and PECO of the mistake, before the transfer request had even been processed. For these reasons, I disagree with Direct. I disagree that the change occurred with Mr. Naborn's consent. Still, I agree that no civil penalty should be imposed on Direct Energy in this case. Our regulations on customer switching do not neatly fit into this situation. Direct Energy acted in accordance with the reasonable reading of the standards governing its conduct as an NGS in a unique situation where the customer initiated the switch, although by mistake. But a common sense business practice would have been for Direct Energy to offer the original terms of the contract and conditions at the outset, not several months later, like what happened here. To repeat, Mr. Naborn immediately notified Direct Energy of his mistake on PECO's automated system, asked Direct Energy to note the issue in the event it received an order from PECO to cancel Direct service, providing Mr. Naborn with the same terms and conditions that he previously received could have avoided the time and expense of litigation as it relates to Direct Energy's involvement in this matter. It's my hope that by placing a spotlight on this case, that will be sufficient to deter mindlessly mechanical applications of the switching processes in future cases where customers clearly do not intend to switch their service. Therefore, I move that, 1, the exceptions of Direct Energy services to the initial decision issued on September 6, 2023 are granted in part and denied in part consistent with this motion, and 2, that the Office of Special Assistants prepare an opinion and order consistent with this motion. Thank you.
Thank you, Vice Chair Barrow. We've heard her motion. Is there a second?
Second.
Seconded by Commissioner Zerfus. Any discussion on the motion?
Chairman, I do have a statement.
Mr. Coleman.
Thank you. I'm going to be voting in concurring and result only. I do have a statement on the matter that articulates the reason for my vote this morning, and I'm going to spare all of us the reading of that statement and just ask that it be entered into the record as though I read it in its entirety. Thank you.
Thank you, Commissioner Coleman. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no.
I'll be concurring in the result only.
Okay. Motion passes by a vote of 5-0, noting that Commissioners Coleman and Yenora concurring in result only. On the matter as amended by the motion, is there any objection to taking the previous roll call? Hearing none, matter passes as amended by the motion by a vote of 5-0, noting that Commissioners Coleman and Yenora are concurring in result only. Madam Secretary.
Turning to page 11, it is recommended that the commission adopt in an omnibus motion both items on page 11, beginning with the formal complaint of Michael Hillman versus the PECO Energy Company, and continuing the omnibus to include both items on page 12, both items on page 13, and both items on page 14, ending the omnibus with the application filed by Meditrans Group, LLC.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Yenora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. Ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 15, and matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended that the commission adopt the proposed order in the application of the York Water Company to acquire certain water system assets from AATG Properties, LLC, doing business as Brookhaven Mobile Home Park in Pelham Township, York County.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Chairman, I have a statement.
Vice Chair Barrow.
Thank you. Please add my statement to the record as though I read it in its entirety. This is an application by York Water Company to acquire the water distribution facilities of Brookhaven Mobile Home Park. The purpose of the application is to enable York Water to connect Brookhaven's residents to a healthy, compliant source of domestic water, where the current owner-operator has requested service from York Water to resolve an outstanding order from DEP. Our staff has verified with DEP that Brookhaven is currently subject to a consent order and agreement for failure to meet the primary maximum contaminant level of tetrachloroethylene. The consent order and agreement mandates, among other corrective actions, that Brookhaven provide public notice of the contaminant exceedance to all Brookhaven consumers. This notice is required every 3 months, so long as the exceedance exist. And additionally, it's significant to note here that the asset purchase agreement that this deal resides on, based on that, York Water will not, nor is it obligated to, begin providing water service to Brookhaven consumers until the closing of the transaction, because the asset purchase agreement is conditioned on the construction of the water main to connect Brookhaven to York's existing water distribution system. At that time, the existing water system will be decommissioned. The Commission's approval of the application would mean that York Water will not provide water to Brookhaven customers until the existing water system is replaced with York's water sources. I would like to commend York Water for stepping up, for addressing this public health issue and agreeing to connect the Brookhaven consumers to its system. I underline York Water's commitment in its application to connect the customers within 30 days of approval of this application. And at the same time, I urge York Water to connect those customers to its system sooner than 30 days, if that is at all technically feasible. Thank you.
Thank you, Vice Chair Barrow. Any further discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. Ayes have it by a vote of 5-0. Madam Secretary.
Continuing on page 15, it is recommended that the commission adopt in an omnibus motion, beginning with the remaining item on page 15, the application of Keystone Metro Fiber LLC, and continue the omnibus to include all three items on page 16, both items on page 17, both items on page 18, and all three items on page 19, ending the omnibus motion with the license cancellations of certain natural gas suppliers.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Vice Chair Barrow. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 20, in matters presented by Chief Counsel Screven and the Law Bureau, it is recommended that the Commission adopt the proposed order regarding the advanced notice of proposed rulemaking order regarding the Commission's role in FERC Order 2222.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfas, seconded by Commissioner Yanora. Any discussion?
Chairman, we do have this joint.
We have a joint statement. Vice Chair Barrow.
Please enter this statement into the record as though read in its entirety. Today marks an important step in the process of allowing flexible distributed resources to participate in the reliability of the electric system through markets at PJM. Distributed resources provide the possibility for those who were traditionally consumers to play an active role in ensuring electric reliability and resiliency for themselves and their neighbors, and often in a less expensive way than traditional large generation that requires delivery infrastructure. Compliance with and implementation of FERC Order 2222 is no small task. Numerous parties must take action to advance the goal of providing distributed energy resource aggregators access to the wholesale markets, including the RTOs, electric distribution companies, and state regulators. We would like to thank our Law Bureau and the Bureau of Technical Utility Services, who developed an excellent and thorough beginning to our investigation of potential regulatory changes needed to support distributed energy resource participation. In addition to the questions we ask in this advance notice of proposed rulemaking, we would like to ask commenters to include any information about how similar changes may be implemented in other states. Alignment of rules and policies may not be possible in all circumstances, but avoiding a patchwork quilt of regulation would also help to optimize deployment. Thank you.
Thank you, Vice Chair Barrow. Any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Continuing at the bottom of page 20, it is recommended that the Commission adopt in an omnibus motion the withdrawal motion filed by Veolia Water Pennsylvania and include and end the omnibus at the top of page 21 with the withdrawal petition also filed by Veolia Water Pennsylvania Wastewater.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfas, seconded by Vice Chair Barrow. Any discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 22, and matters presented by Chief A.L.J. Rainey and the Office of Administrative Law Judge, it is recommended that the Commission adopt in an omnibus motion both items on page 22, beginning with the recommended decision of A.L.J. Chiodo and A.L.J. Arnold in the investigation of the James Black Water Service Company, and ending the omnibus with A.L.J. Watson's initial decision in the formal complaint of PGH Property Buyer, LLC, Elizabeth Kaziva versus the Pittsburgh Water and Sewer Authority.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Yenora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 23, it is recommended that the commission adopt the initial decision of ALJ Coogan in the formal complaint of Keith and Rebecca Hartman versus the Metropolitan Edison Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Yenora, seconded by Commissioner Zerfus. Any discussion? I do have a joint motion with the Vice Chair. I ask the Vice Chair to chair the meeting.
I recognize Chairman DeFrank for purposes of our joint motion.
Thank you. I ask that this joint motion of Vice Chair Barrow be entered into the record as though I read it in its entirety. Before the Commission for consideration is the initial decision of Administrative Law Judge John Coogan, which dismissed the formal complaint filed by Keith and Rebecca Hartman against the Metropolitan Edison Company. The complainants alleged that when Mrs. Hartman was driving home on December 12, 2022, her vehicle encountered a loose electric line on Oak Street in Lebanon, Pennsylvania. The fallen line damaged the vehicle. The complainants alleged negligence on the part of Med-Ed to secure the area and use proper traffic control, resulting in the accident. They allege that Med-Ed jeopardized public safety. For relief, they seek compensation for all damages to the vehicle, personal time associated with the claim for damage, vehicle mileage associated with the claim, lost time at work, lost time due to vehicle inspection delays, and rental vehicle costs. Med-Ed filed an answer and new matter and preliminary objections to the complaint. The ALJ issued an order granting Med-Ed's preliminary objections and struck the request for monetary damages, as such request is beyond the Commission's jurisdiction. The matter proceeded to an evidentiary hearing, and the ALJ issued his ID after the record closed. The record in this matter reflects that a Med-Ed employee responded to the reported outage for a line coming off a circuit near Oak Street. The employee arrived at the fuse switch at approximately 6:31 p.m. on December 12, 2022, and after finding no cause for the outage, the employee re-energized the line. When the line was re-energized, it fell onto the road. Mrs. Hartman testified that her vehicle encountered the line at approximately 6:45 p.m. The Med-Ed employee removed the loose line from laying in the street, and when doing so, saw the complainant's vehicle parked on the road. However, the employee did not realize the complainant's vehicle had been hit by the line until a police officer who had arrived at the scene informed him. Med-Ed determined that the cause of the line falling into the road was that the line was laying loosely against a steel pin and when re-energized, fell down. Although Med-Ed admits that the line became loose, meaning that there was an equipment failure, the initial decision finds that Med-Ed did not violate Section 1501 of the Public Utility Code, which requires public utilities to furnish safe and reasonable service. Based on the record, we disagree that Med-Ed provided safe and reasonable service in this incident. The complainants established a case of unsafe and unreasonable service through Mrs. Hartman's testimony that their vehicle struck wires, which may have been energized on the road. The burden of going forward then shifted to Med-Ed to rebut the complainant's evidence. We find that Med-Ed did not sufficiently rebut the complainant's evidence. Med-Ed's own testimony demonstrates that sometime prior to energizing the line, the wire had already become loose and was laying against the steel pin. The act of energizing the line ultimately caused it to fall onto the roadway. The Med-Ed employee who responded to the outage did not observe the loose wire when he patrolled the area prior to energizing the line. In our view, Med-Ed did not satisfactorily explain why the failure to observe the loose wire was reasonable. Therefore, we find that the complainants met their burden of proof by establishing by a preponderance of the evidence that Med-Ed was responsible for providing unreasonable, unsafe, and inadequate service in violation of Section 1501 of the Public Utility Code on December 12, 2022. Based on Section 3301 of the Public Utility Code, the Commission is authorized to impose a civil penalty of $1,000 per day for each day's continuation of the violation. Noting that the challenges that pro se individuals face when providing technical and engineering violations, the record in this case supports finding one violation of Section 1501, namely the failure to observe a loose wire that fell onto the complainant's vehicle. Accordingly, the statutory maximum civil penalty for this violation is limited to $1,000. We find that the factors and standards used by the Commission to evaluate violations of the Public Utility Code support the imposition of a civil penalty in the amount of $750. Additionally, noting that the significant safety issues raised in this proceeding, we are referring this matter to the I&E Electric Safety Division to review A, the alleged unsafe and unreasonable service issues raised by the complainants besides the singular violation of Section 1501 on December 12, 2022, and B, Med-Ed's practices and procedures as they relate to operating and maintaining unsecured wires or lines resting loose, as well as Med-Ed's practices and procedures when re-energizing lines. I&E may take whatever further action that may be warranted. Therefore, we move that 1, the initial decision of Administrative Law Judge John M. Coogan issued on December 18, 2023 is reversed. 2, the complaint of Keith Hartman and Rebecca Hartman against the Metropolitan Edison Company at docket number C-2023-303-8465 is granted in part and denied in part. 3, in accordance with Section 3301 of the Public Utility Code, the Metropolitan Edison Company shall pay a civil penalty in the amount of $750 within 30 days of entry of a final opinion and order. 4, the matter be referred to the Commission's Bureau of Investigation and Enforcement Electric Safety Division for review and such further action as deemed appropriate. 5, the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you.
Thank you, Chairman. Is there a second for the motion?
Second.
Seconded by Commissioner Zerfus. Any discussion on the motion? Hearing none, all those in favor say aye.
Aye.
Any objections? Hearing none, the matter is adopted as amended by the joint motion of Chairman DeFrank and myself by a vote of 5-0. Gavel's yours.
Thank you. Madam Secretary.
Finally, on page 23, it is recommended that the Commission adopt the initial decision of ALJ Heap in the formal complaint of Luke Stanshine versus the Philadelphia Gas Works.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, seconded by Vice Chair Barrow. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Mr. Chairman, that concludes the regular agenda. Turning now to the carry-in. On page 1 of the carry-in agenda, it is recommended by the Office of Special Assistance that, consistent with 4 PA Code Section 1.43C, the notational votes and actions taken by the Commission on February 20, 2024, on the opinion and order consistent with the motion of Commissioner Zerfus in the formal complaint filed by Salvatore and Elizabeth Galante et al. Versus the Pennsylvania American Water Wastewater Company be recorded and entered in the minutes of this public meeting.
Is there a motion to consider the staff recommendation?
So moved.
Motion made by Vice Chair Barrow, seconded by Commissioner Yonora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5-0. Madam Secretary.
Turning to page 2 of the carry-in, it is recommended by the Law Bureau that the Commission adopt the proposed final form rulemaking order regarding hazardous liquid public utility safety standards at 52 PA Code, Chapter 59.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Yonora. Any discussion?
Mr. Chairman.
Commissioner Zerfus.
Mr. Chairman, Madam Secretary, I have a statement in this matter. Please add it to the record as if I read it in its entirety, but I probably will, so bear with me. But I wanted to take the opportunity today to voice my support of this final form rulemaking regarding hazardous liquid public utility safety standards. This final form rulemaking represents a long overdue step forward towards improving pipeline safety in the Commonwealth. I would also like to take the opportunity to highlight that pipelines are critical to Pennsylvania's energy infrastructure and that there is a shared goal among all of our vested partners to ensure that hazardous liquid public utilities construct, operate, and maintain pipelines in a manner that ensures the protection of public health, safety, and the environment. The final form rulemaking is the direct result of concerns raised by the public and those identified by the Commission based on its oversight of recent pipeline construction in Pennsylvania. This rulemaking establishes Pennsylvania-specific safety standards that are more stringent than, but are still compatible with, the minimum federal safety standards, and for good reason. So Pennsylvania is unique. We boast more miles of streams than any other state. They're estimated at over 85,000 stream and river miles. We have varied geology, and we have 3.5 million residents relying on private water wells, and we've had recent pipeline projects located in densely populated areas. So to that end, I appreciate the goal of this final form rulemaking to address the potential for spills, leaks, subsidence events, and water supply contamination when hazardous liquid public utilities construct, operate, and maintain pipeline facilities. This final form rulemaking does this by adding requirements for accident reporting, public notice of when construction activities will occur, adequate analysis of potential impacts when crossing waterways and roadways, identification of nearby water supplies, coordination with local communities and emergency responders, training, public outreach, and education. I stress that the rulemaking is necessary for the protection of public health, safety, and the environment, while ensuring that hazardous liquid public utilities in Pennsylvania furnish and maintain adequate, efficient, safe, and reasonable service, and that facilities make all such repairs, changes, alterations, substitutions, extensions, and improvements necessary and proper for the safety of the public. I would also like to take the opportunity to acknowledge that not all pipeline projects pose the same level of risk, and that these rules are not meant to dissuade pipeline construction. It is important to note that this rulemaking applies only to pipeline operators of interstate pipelines that are jurisdictional to the Commission as hazardous liquid public utilities. This is a narrow subset of pipeline operators, and this final form rulemaking does not encompass non-public utility gas and hazardous liquid pipelines. Additionally, the rulemaking does not contain any retroactive design or construction requirements for pipelines that exist when this rule is finalized. However, the operations and maintenance, accident reporting, and public awareness regulations do apply to existing hazardous liquid pipeline facilities. So significantly, the goal of the final form rulemaking is to give the Commission staff the tools they need to ensure proper oversight given our state's-specific needs. This is just one step in the Commission's efforts to address a comprehensive process to address pipeline safety. So as noted in the order, the Commission continues to examine pipeline integrity issues and will continue to consider efforts to further address the safety of public utility infrastructure. Thank you.
Thank you, Commissioner Zerfus. Any further discussion? I do have a statement in this matter. I ask that my statement be entered into the record as though I read it in its entirety. Today's consideration of the final form rulemaking concerning hazardous liquid public utility standards represents a significant milestone for pipeline safety in the Commonwealth. The rulemaking establishes additional safety requirements that surpass but do not conflict with the minimum federal pipeline safety standards that this Commission has already adopted. The rulemaking focuses on Pennsylvania's experience with the construction and operation of the public utility pipelines transporting highly volatile liquids and other hazardous liquids in all areas between points within the Commonwealth, including densely populated locations, areas with unique geophysical features and subsurface conditions, and wetlands. Of significance, the rulemaking addresses the outcry for greater public outreach from hazardous liquid public utilities. The rulemaking imposes notification requirements on HLPUs to notify local government officials and emergency management services 30 days in advance of pipeline construction, whether the method of construction involves horizontal directional drilling, trenchless technology, or direct bury installation. The rulemaking also directs HLPUs to conduct liaison activities with emergency responders and provide enhanced baseline messages to the affected public twice a year. If requested, the HLPUs will be required to provide emergency response plans to school administrators with schools located within 1,000 feet of the center line of the pipeline or the lower flammability limit, whichever is greater. The rulemaking seeks to enhance the safety of existing pipelines through increased ground patrol and corrosion control procedures, among other means. For new pipelines that will be constructed, the rulemaking mandates geotechnical evaluation of subsurface conditions before and after construction. The rulemaking also prohibits new pipelines from being placed under dwellings and requires a minimum of 12 inches of clearance between a newly constructed pipeline and any other underground structure. This list of safety enhancements is not exhaustive, but rather those that I wish to highlight. I recognize the pipelines are vital to our economy in supplying necessary fuel for daily activities and for job creation. Pipelines are the safest way to transport hazardous liquids, including petroleum products. Pennsylvania's experience, however, demonstrated that a more comprehensive and complete regulatory framework for HLPUs was necessary to limit the occurrence of subsidence events, pipeline accidents, and complaints. For these reasons, I support the final form rulemaking. And finally, I would like to take this opportunity to commend the team of Law Bureau attorneys and staff who worked on this matter for their hard work and dedication in reaching this point of the rulemaking process. Thank you. Any further comments?
Chairman, I do have a couple of comments I'd like to share.
Mr. Coleman.
Thank you. First of all, I'd like to associate myself with your statement. I think it's very articulate and certainly gets to the heart of the rulemaking itself. This is a highly anticipated rulemaking that commenced back in 2019, and for good reason. We at this commission heard an awful lot from the citizens across the state of Pennsylvania. And in fact, this rulemaking probably generated more comment than any other rulemaking during my 14-year tenure at this commission. So I think this was a very important one, and it was important for this commission to listen and to take those comments under consideration. I think it's probably noteworthy this morning in recognizing that there are probably some who submitted comments, and perhaps not, but they may be frustrated that this particular rulemaking does not go as far as perhaps some would like. And I think it's important just to remind all of us that we as a commission are constrained. We're constrained by state law and by federal law. And I think that what we have concluded on today with this rulemaking is a good balance of those comments and keeps us within the fairway of those regulations and laws that we need to be compliant with. I think the last thing, and both Commissioner Zerfas and Chairman DeFrank had commented on this in their statements, and I just maybe want to conclude on this point that a lot of what is included as amendments and enhancements in this rulemaking are really around safety. And I guess in my view, I see that as the win-win. This is about safety for the community in which these facilities are traversing. It's safety about those who live contiguous to the rights-of-way of these facilities. It's about safety for the facility owners and those contractors that are working on those facilities as well. So I think this is a very good piece of work by this team. And I also want to commend the Law Bureau staff for really doing a nice job in taking all of those comments into consideration and concluding with what I think is a very good conclusion. So thank you.
Thank you, Commissioner Coleman. Any further discussion?
I do have a brief statement, Chairman.
Vice Chair Barrow.
Verbal statement. I will always vote to support a rulemaking that I think is going to further public safety within the Commonwealth. And I think that this one will. But I do want to say, I think we could have gone further. I think we had a chance for kind of like a moonshot, and we probably aimed for Kansas. And I hope that in the future, we will keep working on this issue. I do not believe that there were any legal obstacles in the way. Thank you.
Thank you, Vice Chair Barrow. Any further discussion? Hearing none, all those in favor, please say aye.
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 Those opposed, no. Matter passes by a vote of 5-0. Madam Secretary.
Mr. Chairman and Commissioners, that concludes all agenda items to be considered today.
Thank you. Before we adjourn today, I would like to recognize Commissioner Zerfus, and I remembered that because I wrote it down on my list. Commissioner Zerfus.
I made sure you wrote it down, too, to make sure you remembered. But thank you for the point of personal privilege, Mr. Chairman. I just wanted to make an announcement on some staff changes in my office for public awareness purposes. But many of you have known that Lillian Harris in my office has retired from full-time state government service. And in her absence, we have Tom Capper, who has assumed the role of Chief of Staff in my office. Tom, I'm going to embarrass you. Give us a little wave. Thank you. And since I announced it publicly, you're stuck, so sorry. But to round out the already existing complement in my office of Kate McMullen, Elizabeth Davis, and Jamie McClintock, we welcomed Abdul Berry to the office literally 2 days ago. Abdul's waving his hand. Abdul came to the PUC most recently from the Department of Insurance, where he spent many years as the legislative director over there at the department. He also has experience working at the Departments of Aging and Human Services, and he has been a committee executive director at the House of Representatives. So he has extensive state government and legislative experience. He's also a Pitt alum, so for those of you who are also Pitt alums in the audience. And he has undergrad and graduate degrees in economics, so we will be putting that to good use, Abdul. But I just wanted to make sure that folks knew that Abdul started. He just started this week, and if you see him after the public meeting, maybe you could say hello. Thank you very much.
Thank you, Commissioner Zerfus. If there is no other business to come before us, is there any objection to adjourning the meeting? Hearing none, we are adjourned.